disclosures, and then I'm going to very briefly deal with discrimination. I'm not going to spend a lot of time on this because Emma Saunders, one of my colleagues, is doing an actual dedicated session on that this time next week. So I don't want to steal her thunder and I don't want to go into too much detail, but we will cover it off in this morning's session. So the situation we find ourselves in with the pandemic is an unusual one. Many employers will be grappling with the guidance to provide a COVID secure workplace. They will be implementing social distancing, which they have never had to do before. They, as I mentioned earlier, they are now in a scenario where potentially very innocuous activities could potentially become dangerous. And then on the other side of that, we have a situation where employees are no longer shielding as of Saturday just gone, 1st of August, and potentially very reluctant to come to work, perhaps scared to come to work, worried about coming to work. And it's obviously grappling with both of those issues, which potentially leaves scope for error. And that's going to hopefully be something that I'm going to be able to resolve today in the sense of educating you and sharing with you the knowledge so that you are asking yourselves the right questions if you find yourselves in this situation. So the types of questions we are being asked as a team around this health and safety subject. And I suppose just to be clear from the outset that the idea this morning is not for me to start going through, my specialism is not health and safety, undertaking risk assessments, you know, what is reasonably practicable by way of measures if risks are being identified. That's something that our health and safety team will obviously be able to assist you with. But this morning's session is very much focused about dismissals concerning health and safety and placing employees to a detriment in scenarios where health and safety is an issue, okay? So the types of questions that we're being asked are set out on the slide, and I'm hopeful that as I make my way through the session this morning, I'm going to hopefully bottom out all of those. If you don't agree or you feel some of those remain unanswered, then we can circle back to those and pick them up later. But as I say, the intention is that as I move through the session, I'll deal with all of those. Okay, so without further ado, it is going to be a little bit legalistic in the sense that we are going to visit and look at the statute, but hopefully I'll be able to bring the session to life by sharing some practical examples and going through some existing case law to put these concepts and the legislation into some meaningful situations. Okay, so before we look at section 100, I just want to refresh or remind ourselves that in Section 2 of the Health and Safety at Work Act 1975, there is an obligation on all employers to ensure the health and safety of its employees as far as is reasonably practicable. So I'd like us to at least have that in our mindset when we're working our way through this session. This isn't new law. This isn't something that's occurred recently. 1975 Act's been around obviously since 1975, and Section 100 is in the Employment Rights Act 1996. So these concepts have been around for a long time, but obviously, as I said, they haven't been considered in the context of a pandemic. Okay, so let me just get a bit closer to the screen, and I want to go through the legislation with you. Okay. So Section 100 of the Employment Rights Act, so what does this say? So it states, subsection 1, an employee who is dismissed shall be regarded for the purposes of this Act as unfairly dismissed if the reason, or principal reason, for the dismissal is that, and the relevant clauses are all the way down here, D and E. So D states, in circumstances of danger which the employee reasonably believed to be serious and imminent, and which could not reasonably have been expected to avert, he took appropriate steps. So that might well be he leaves the workplace or he refuses to come back to the workplace. So just to reflect, the key questions that I think this section throws up is, well, circumstances of danger, what's danger? What's the employee's reasonable belief? What does that look like? And what is serious and imminent? Is the risk of getting coronavirus, is that serious and imminent risk? I don't know, we're going to look at that today. So just to repeat, so if you are dismissing an employee because they have taken steps which they believe are appropriate in a scenario where they've identified a risk which they believe is dangerous and presents an imminent and serious risk of danger, and you dismiss them because of that, that will be automatically unfair. Now, I appreciate it's very wordy. Don't, be concerned. I am going to break this up for you this morning. I'm going to look at, what is danger? What is serious and imminent? What does a reasonable belief look like? And I'm going to take you through all of that. So Just to be clear as well, at subsection E, in circumstances of danger which the employee reasonably believed to be serious and imminent, he took appropriate steps to protect himself or others. And we'll see later on in the session that becomes very relevant. Okay, when we're looking at appropriate steps, that will be considered, and subsection 2 tells us this, that will be considered, so appropriate steps to be judged by reference to all the circumstances, including, and in particular, so this is the employee's knowledge of, and the facilities and advice available to him at the time. Now, as we go through the session, we'll reflect on subsection 2 because it keeps coming up time and time again. Okay. So on this second slide, I'm not going to go through it. What I've done is I've tried to just highlight the main key terms so that when we go through it throughout the session, you can reflect back and think, oh, that's where that fits into the legislation. Okay, section 44 is in essence the same, and the content in principle mirrors that of section 100. But what section 44 relates to is not dismissal. What it states is an employee has the right not to be subjected to any detriment by any act or any deliberate failure to act by his employer. And if we go down to D and E, we'll see the wording is exactly the same. So he's not to be put to a detriment by the employer in circumstances of danger, again, which the employee reasonably believed to be serious and imminent, and which he couldn't have reasonably be expected to avert. And he refused to return to his place of work or not come to the place of work. So that wording is replicated in its entirety, as is subsection E and as is subsection 2. So let's break this down then. Let's look at these different sections. But before we do, let's just reflect. So section 44, detriment, so potential protection for the employee on the basis that they are able to satisfy, and I'll call it a gateway. So there are set conditions. Is the danger? Is it serious and imminent? Is there reasonable belief? That to me is almost like a gateway which the employee has to satisfy. And if they can, potentially, if they do an act and the employer responds by dismissing or placing them to a detriment, it's going to be automatically unfair, or they may have a case under section 44. Okay. Relevant to note from the outset is an employee doesn't have to consult with their employer about this, about them taking action. So it could be something as simple, applying it to the coronavirus, as they attend work one day, they've identified a risk, whether that be no hand sanitizer, whatever it may be, and decide that actually this situation is risky, I'm leaving, and then they would tell the employer, you know, I'm not coming back to work. So there's no obligation on the employee to consult and engage in consultation with the employer, which is, I think, quite interesting. Section 44 and 100 also extends to protect those staff who are maybe part of a health and safety committee or have health and safety functions as well. So that's not going to be focus of the session, but I just wanted to at least bring that to your attention. Okay. Who qualifies for protection? So on the assumption that that gateway is satisfied, and that gateway we're going to go through in much more detail shortly, who can enjoy this protection? Well, it's all employees. You do not have to have 2 years continuous service to enjoy this protection. So, you know, you could have somebody in their probationary period able to enjoy this protection, as well as somebody who's been with the business for 26 years. There is a suggestion that the legislation actually extends beyond employees, and where we believe that to come from is the European directive. So I'll just read out the wording. So the Health and Safety Directive at Article 3 states that any person employed by an employer, including trainees and apprentices, can enjoy the benefit. So in my view, my advice would be that this protection could potentially extend to workers. Just be mindful of that. Okay, so let's break this down. Let's break this section 100 and the language mirrored in section 44 down. So it is the employee's belief that matters. The law is not concerned what the employer thinks. Okay, so that's an important thing to understand from the outset. And an interesting case, which I haven't put on the slide, but it's a case of Udar versus Esportis Group. In that particular case, an employee was refused to mop a floor. He'd been given a reasonable instruction by his manager to do this, and he refused. His belief was because there were some exposed wires on the wall following some maintenance work, he believed it wasn't safe for him to mop. And the employer dismissed, and the employer relied on a report prepared by a manager, a different employee, to justify the dismissal, to say that the report concluded that it was safe, and they said, well, on that basis, we're dismissing. Now, what the judge said, and I've got an extract here from the appeal judge Richardson, what he said in that case was, the mere fact that the employer disagreed with the employee as to whether circumstances of danger existed is irrelevant. Parliament intended the employee could take appropriate steps to protect himself with reasonable belief that there was a threat of serious and imminent danger. So it really affirms to us that the law will not be concerned about what the employer thinks. It will be the employee's belief. So my kind of knee-jerk response to that would be, well, you know, that's quite a concerning scenario for an employer, because, you know, a reasonable belief for an employee, how can we control that? How can we have any impact on that, etc.? Well, I think we can. And I think the case of Hamilton demonstrates how we can influence reasonable belief and how we may have a hand in trying to control that to a certain degree. The case of Hamilton versus Solomon and Wu Limited. In that case, the employee was in his probationary period. So again, reinforces the point that I said before about this protection extends to all employees, not those just with 2 years continuous service. He was asked to work in the workshop and he refused. He said it was dangerous and unsafe because of the atmosphere and because of the dust. And in this particular case, the Employment Tribunal found that because the employer had addressed all health and safety matters and regulations robustly and thoroughly, they had observed suitable masks, they had appropriate dust extraction systems in place, and importantly, they had engaged in consultation and discussion with the employee about this. They held that the employee did not have reasonable belief that there was a risk of danger which was serious and imminent. So what can we take from that case and apply it to the circumstance that the pandemic and COVID presents to us? Well, practically, I would say, reflecting on the case, that I would, in the area of risk assessment, I would ensure that we are discussing with our staff what measures are put in place. So what risk have we identified? What measures have we put in place as an organisation? And make sure that we're fully consulting, not just with committees and our health and safety reps, but individuals on what we are doing as an organisation to trying to create a safe working environment. Now, why this is obviously important is because if we're not doing that, then the employee is going to make their own assumptions. You know, they're going to make their own judgments, they're going to worry, but we can almost dampen those, you know, flames of concern by saying, well, these are the measures that we're undertaking, and discuss those with the employee. And on that basis, we would like to think that actually, if that information has been provided and an employee can demonstrate that they have taken measures as far as is reasonably practicable to do so to create a safe working environment, I think it would be pretty difficult for an employee to show reasonable belief in that scenario. Now, what the case of Hamilton did, and I've set out on the slide, I think it just echoes what I've just said really, is almost like three main points. So firstly, establishing whether there is in fact circumstances of danger, and we'll go on to looking at that in a moment, and that ultimately is a question for the tribunal to decide. Secondly, whether the employer reasonably believed the danger was serious and imminent, and we've just discussed practically how we can have a hand in that potentially. And the third is, what is the reason for the employee's dismissal really? So just, I appreciate I have kind of made the point now, but another case which I want to share with you is the case of, and that's on the next slide, Edwards and others versus the Secretary of State for Justice. And this case again reinforces that point about don't make any, I suppose, assumptions of knowledge, and making sure that you place the employee in an informed position, which I suppose just before we go on to looking at the case, because shielding has now gone, the government is no longer recommending employees shield, I think you're going to have a whole kind of group potentially of employees that may not have been party to some of the discussions which have already taken place regarding health and safety, what measures have happened, what new systems are in place, what new systems of work have we adopted to try and create a safer working environment. They may not have necessarily been party to those. So I think a part of that integration piece with those people that have previously been shielding that are now going to be coming back into the workplace, making sure that you're having those conversations and placing them in an informed position is going to help significantly with integrating them back into the workplace. So to go back to the Edwards case then, here in this case, there were 8 prison officers who worked at Dartmoor prison, and they were refusing to go to work because the road leading up to the prison, because there'd been significant snowfall, was very dangerous. Now, what the employer did is it put on a 4x4 vehicle to basically transport their staff to the prison, of which the employees, and in particular these 8 prison officers, were well aware. What the prison officers sought to do when they were dismissed and they were looking to claim Section 100 was to say, well, you know, on the basis of Section 100, you can't dismiss me automatically unfair, and the reasonable belief that they were circumstances of danger that were serious and imminent. And what the tribunal held was that they could not have had reasonable belief because they were well aware of what measures the employer had undertaken to make sure that that danger, which potentially could have been imminent and serious, was taken away by the provision of this transport to the prison. So I think we've kind of done that point to death now, and I think hopefully you can understand that, yes, on the face of it, you think, well, reasonable belief, or, you know, that employee could have any kind of reasonable belief, but I think if you're communicating with your staff, you can have a handle on that. You can try and ensure that you place them in an informed position as possible. Okay. Let's look at the next part of the legislation, danger. So what do we mean by danger? What does danger look like in the context of Section 100 and Section 44? Well, it has a very wide meaning, and danger relates to circumstances of danger and does not just need to relate to the workplace itself. Okay, and the case of Harvest Press Limited versus McCaffrey demonstrates this point in practice. So the case here, the claimant was involved in an altercation, or was the victim, perhaps is a better way of explaining it, in an altercation by another employee. Subsequent to which he immediately left his shift, and he told the employer, he rang up the employer and said, I won't be coming into work until you can guarantee my safety. And what the employer did in that scenario was they took that as a resignation and issued him his P45. And the tribunal said that, and was comfortable that that did provide circumstances of danger, even though it wasn't the actual workplace itself. So the employee, the aggressive, or the employee who had been the person who had created the altercation, that was the danger, and the tribunal agreed with that. So applying this to COVID and the situation that the coronavirus presents to us in the workplace, you could see a situation potentially where an employee is working with a colleague and the colleague has developed a continuous cough, seems to be sweating profusely, and decides, actually, I'm not going to be working alongside that employee. Now, practically, we'd hope that that wasn't going to happen, because we'd hope we'd have policies and things in place to make sure employees aren't coming into work in that scenario. But just by way of demonstration, you could see that situation arising, and that employee saying, well, I think this scenario presents a circumstance of danger. Now, the important thing to note about when we're looking at circumstance of danger is that it's whilst the danger persists. So this will potentially be a moving feast as we look to hopefully get a vaccine, as maybe the R rate starts going down. There may be a suggestion that actually is there danger, once there is a vaccine, etc. So it's something to be mindful of. But I think the key point to note with this, it's not just the actual workplace itself. It can extend to the risk that other colleagues potentially could present to that individual. So something to be aware of. Okay. Serious and imminent. So we know what reasonable belief looks like. We know what danger can look like in the workplace. What about serious and imminent? Well, I think the starting point with this is to look at the Health Protection Coronavirus Regulations 2020. Now, that legislation I'm not going to refer to again within this session, but what it does do at Regulation 3.1 is state this. So it states, these regulations apply where the Secretary of State declares by notice that the incidence or transmission of coronavirus constitutes a serious and imminent threat to public health. Well, Helpfully, that piece of legislation, although not directly relevant to what we're talking about today, clearly in black and white refers to the coronavirus being serious and imminent. I think it will be highly unlikely that an employer is going to be able to argue that potentially getting coronavirus is not serious. I think it's more likely that the tribunal, when it's considering serious and imminent, may grapple or may have some thoughts about the second element of this test, if you will, which is imminent. So I think it would be naive for us to suggest that we'd have any sort of counter argument to say coronavirus is not serious. We know that it can potentially lead to death. So I think that's not an argument. What may present some scope for argument is whether it's imminent. And what I wanted to do on that aspect of it is just look at a particular case, just to see how we may look at that and apply it to the circumstance of the pandemic in the workplace. And that's the case of ABC News Intercontinental Inc. versus Gisbert. Now, in this case, it concerned the claimant, who was a news reporter, and they had always historically worked in war zones. Now, the news reporter had stated that he or she, no, I can't remember if it was a he or she, no longer wished to work in a war zone and refused a particular piece of work in Afghanistan and Iraq. And the employer decided not to renew the contract and stated that they wouldn't be engaging them anymore. The employee sought to argue Section 100, and the tribunal said, well, you've refused to go to the war zone. So there was never a situation where there was circumstances of danger which were serious and imminent, because you weren't you'd said you weren't going to go into a war zone. So the potential danger isn't necessarily going to satisfy that test. Now, in my view, what I kind of pondered on was, would the case have been decided differently if he had actually attended the war zone, got there, and then decided, actually, I'm going to leave here, this is too dangerous. And actually, in that scenario, could it be argued that the circumstance of danger was serious and imminent? And I think potentially it could. So the relevance, I suppose, of this is that, yes, potentially the risk of the fear of catching coronavirus, in my view, could potentially amount to circumstances of danger that are considered to be serious and imminent. Now, obviously, as the pandemic evolves and as potentially we have vaccines, etc., the landscape on this may change, but I think it's reasonable to assume that it's something for us for sure to be considering in some depth before we're making any decisions to dismiss. And, is the employee able to satisfy that gateway of danger in this scenario of serious and imminent? Are they able to satisfy that with reasonable belief? Okay. The point I mentioned right at the beginning when I was going through the legislation, when we looked at subsection E, is reference to danger to themselves or others. So what does or others mean? Now, I think obviously we looked at some of the cases in relation to presenting danger. Obviously, we concluded that danger might be other employees. But when we're talking about kind of averting the risk to protect an individual themselves and others, what do we mean? Now, a case called Maziak versus City Restaurants, I haven't put on the slides, but I'm just using this really to bring this concept to life, really. And again, it obviously wasn't considered in the midst of a pandemic, but in this particular case, a chef had refused to cook chicken that hadn't been thawed properly, and they were dismissed. And they looked to cite Section 100 as protection. And at first instance, at tribunal level, the tribunal held that the risk was to others, it was to customers, and held that Section 100 would not apply. That was not agreed by the Employment Appeals Tribunal, and what they said was that actually the risk to the customers, because of the wording of the legislation and how it refers to averting danger for themselves or others, it would include customers. So if we apply that to the pandemic, my thoughts on this are that actually those individuals who have vulnerable members of their family that live in the same household that were previously shielding, there may be some scope that even though the danger they believe being in work, the risk of coronavirus presents is not to themselves, it's actually to their family member, they may well be able to assert the protection on this legislation, but on the basis that all the other building blocks and all the other gateway elements are satisfied. So again, something for you to be alive to. What about the commute? Do we think that the commute presents a risk? Circumstances of danger which are serious and imminent, and the employee may have reasonable belief that it does so. And would the legislation extend to that? I think potentially it could do, but I think with this on the basis, and we'll look at kind of my guidance shortly about how then do we deal with these types of situations where people are refusing to come into work and we need them in work. How do we deal with that? My view on this one is that actually we could potentially make adjustments in the sense of if somebody has to travel by public transport and they consider that presents a danger, circumstances of danger, able to satisfy that gateway test, you might say, well, actually what we'll do is we'll flex the start and finish times ever so slightly to mean you don't have to travel peak time. Or we may be able to offer a car parking space. So, you know, in the current situation, and I think you could travel by car. And I think this is particularly relevant, maybe these types of points to consider for those that have been shielding, almost kind of preempting what concerns and issues may well arise. And maybe, you know, it would be well advised to think about those and what, as a business, you may be able to accommodate. Now, I'm not naive to think that this is obviously not always possible, because you may work the shift pattern, people need to turn up for shifts, etc., on time at a set time, but just give it some thought, because my views are that potentially the wording of the legislation is such that I think it's wide enough to potentially cover the commute as well. Okay, so why am I spending time breaking this down? Why are we concerned by this? You know, what can we do? So, you know, what I don't want to do is people to be worried and think, Kimberly, I feel like you're telling me that if an employee satisfies all of these gateway points, then we're in a situation where we're never going to be able to dismiss people. And actually, we can't present a safe place of work for them to work in. So where do we go from there? That is absolutely not what I am saying. What I am saying is that potentially, if an employee is able to satisfy that gateway about circumstances of danger, which are serious and imminent, of which they have reasonable belief, and they've taken appropriate steps, i.e. refusing to come into work, if as a business, as a knee-jerk response to that, you're dismissing them, my view is it is going to be an automatic unfair dismissal, yes, because they have taken those appropriate steps and you're dismissing them in retaliation to that, almost as a punishment. And I think in that scenario, yes, it is going to be incredibly risky, and you are probably going to be landed with an automatic unfair dismissal. That is distinctly, well, it's subtly, perhaps more so than distinctly, it's subtly different, but importantly different to a situation where you're saying, we understand what you're saying, let's look at the circuit, what are your concerns, let's talk about your concerns, sharing the measures that you've implemented in the workplace to try and create a safer environment, share those with the employee, talk to them about it. It may be appropriate to get them to occupational health so you can fully understand the extent of their condition and how the workplace may or may not present risks. Having had all of that dialogue, if your conclusion is that actually the circumstances of the business are such and your condition is such that actually, having done everything that is reasonably practicable for us to do as an employee, we still can't provide a safe environment for that employee to return to, then in that circumstance, you may be able to show a fair dismissal. And the reason for that dismissal would be for SOSR or some other substantial reason. So what obviously wouldn't be misconduct, what you would be looking at is some other substantial reason. Now, in relation to the process to follow before you get to that decision, to me, it needs to mirror the thoroughness of how you would deal with a disciplinary or capability issue. So make sure you're investigating, make sure that you are having a full hearing, giving them the right to be accompanied, probably getting them to occupational health, discussing at length what measures you've done, getting comments and representations on those, etc. I would advise that that is done thoroughly in that fashion before you reach to that SOSR dismissal. Now, I heard an example on a session that I attended, which I thought kind of brought this kind of subtle distinction to life, really. And it was an example where they said, imagine this, imagine that you are a crisp packaging factory, and you have an employee who works for you who's got a really serious nut allergy, the kind of nut allergy where if they touch nuts, they're going to die. As a business, you make a business decision that actually, not only we're going to package crisp, but we're actually going to diversify, and we're going to start packaging nuts. Clearly, that is going to present circumstances of danger, which the employee may reasonably believe present circumstances of danger which are serious and imminent. I think that is undoubtedly the case. However, the business have made this decision to diversify and generate a new income stream. So how do we marry up? Well, if the employee said, well, I'm not going to be coming into work, and the employee said, right, I'm inviting you to disciplinary, and I'm going to dismiss because you're saying you're not coming into work. That is different to inviting an employee in, investigating his, situation, talking to him about his condition, getting to occupational health, getting their input. What is the extent of his nut allergy? Is there anything we can do by way of reasonable adjustments in the workplace? If the conclusion is we're not, and then you render a dismissal in that scenario because you are looking at all of the circumstances collectively, that is different to punishing and retaliating to the employee's protected and appropriate protected conduct or appropriate steps. So I don't want people to be, come away from the session thinking, oh gosh, that means that we're never going to be able to dismiss, even if we've done everything that we reasonably could have been expected to do. That's not the case. But what I want you to ensure you're doing is asking the right questions, looking at the situation, asking the right questions of yourself, making sure you look at those gateway conditions. Have they been satisfied? What are you doing as a workplace? Have you discussed, is occupational health appropriate before you dismiss? And for those HR3 members, when you've asked us the question, maybe can we dismiss if someone refuses to come in, you now probably appreciate why it's not necessarily a yes or no straightforward answer immediately that we're able to give, because it's much more complex than that. Okay, so we've talked about how you may tackle it. What happens if you get it wrong? Why is it so important to get this right? Well, it's obviously important to get things right because we don't want to be unlawfully dismissing anyone, full stop. But the financial ramifications can be significant. Compensation award for a Section 100 claim is uncapped, okay? And this is a case for what we would normally call short service dismissals. So it's irrelevant if someone's been with you, for 3 months, their assessment on compensation would be looked at in the same fashion as somebody exposed to that scenario has been with you for some time. So be mindful of that. In relation to Section 44, so when we're looking at the detriment piece, so, maybe saying to an employee, well, we're not going to pay you, or because somebody, might have raised a concern regarding health and safety, or saying not coming in, we're going to not put you forward for a promotion, for example. If that the type of treatment that the employee has been exposed to and they're asserting Section 44 instead of Section 100, the tribunal will assess compensation in that scenario to the extent which is it considers just and equitable. And it will do that by looking at the infringement to which the complaint relates and any loss which is attributable to the act or the failure to act. So that might be expenses incurred, that might be a loss of benefit that they might reasonably have been expected to receive. So it potentially can be quite extensive. So obviously want to bring that to your attention. Hopefully we will never be in that scenario. We don't need to even concern ourselves with compensation, but just so that you're aware that the ramifications, not least financially, of getting this wrong are significant. On the detriment piece as well, in 2004, we saw the case of Vertigo Senior School against Boyle. And in that case, the tribunal said that losses in relation to detriment should be assessed in consideration or looking at how we would assess compensation with regards to unlawful discrimination. So this suggests that an injury to feeling award could be made as well for a detriment breach under Section 44. So again, be mindful of that. Okay. Before I look and move on to considering some of the other areas, kind of health and safety related, which offers employees protection, just this point where I've said involuntary furlough in retaliation to protected conduct could be considered a detriment. So looking at the distinction, that subtle distinction that I made between penalising somebody for protected conduct and dismissing them perhaps for misconduct because they're not coming into work, and the distinct difference to that to then an employee looking at all the circumstances before they made a dismissal. That concept is similar to what I'm trying to get at here. So if an employee is saying, I'm not going to come into work because I think it's dangerous, I think there's a risk I'm going to get coronavirus, and you say, right, we'll put you on furlough then, 8% pay. So they've reduced their pay by 20%. Doing that as a kind of knee-jerk response could be seen as a kind of punishment, retaliation to a protected act or appropriate steps. So just be aware of that. I'm not saying it might not be possible, but again, you should be looking at that in the circumstances in the round, discussing it with them, looking at all the factors we talked about, not just a knee-jerk response to punishing the employee in effect for not coming into work. Okay. So other areas of law to consider, just reflect on the time. 40 minutes, fine, okay. Other areas of law to consider. So I suppose just before we go into this, by all means, there may not be questions, but, do shout out if there is anything, and raise your hand, and Charlotte will unmute you. You can ask your question. And I'm happy to take any questions now before we move on to this next piece to capture the area that we've just looked at, if people want to. I'll give you a minute just to see whether any questions are raised. Charlotte, if you want to let me know if they are. I'll just look at the... No, nothing coming through. Okay, well, I'll just carry on then, and we'll leave questions to the end. I don't envisage the session will take as much over an hour. I appreciate probably a lot of people getting Zoom fatigue with all sessions being run virtually. But so the other areas of law to consider, which still have a health and safety element or I suppose driver to it. Oh, can't seem to change. Could potentially be constructive unfair dismissal. So we'll look at that one first. In danger of teaching people grammatical kegs, I'll just recap quickly for those that aren't familiar with the concept of constructive dismissal before we start applying it to health and safety. So constructive dismissal in its basic form is where an employee alleges that an employer has committed what we call a repudiatory breach of the contract of employment. So they breached a term which goes to the absolute heart of the contract of employment, and in response to that, the employee believes that they have no other choice but to resign. That presents, if it becomes contentious, itself as a constructive unfair dismissal claim. Now, if we look at that in the context of health and safety, we can see that an employer's breach of health and safety could potentially amount to a repudiatory breach, which could give the employee rise to resign and look to claim constructive unfair dismissal. But something perhaps that some of you may not be aware of is that actually there is also scope for the constructive dismissal to be automatically unfair. So what this means is that actually those employees that haven't been with us for 2 years, if they are able to show that the employer's breach is in response to the employee's protected conduct that we talked about before, about these appropriate steps to avoid circumstances of danger, which is serious and imminent, if the employer's breach is in response to that, they may be able to be successful in raising a automatically unfair constructive dismissal where they wouldn't need length of service. So this is an important point for you to, I suppose, be aware of. I suppose it's things like, if someone's refusing to come into work because they've raised a concern and you say, right, well, we're not going to pay you, we're going to suspend you, we're not going to pay you. Again, we're looking at that kind of penal response, that punishment type knee-jerk response. You may find that employer says, right, well, I think that the fact you're not paying me, that's a term that goes to the heart of the contract of employment. And you've done that because I've done this protected act. So I'm going to claim constructive unfair dismissal, but automatic constructive unfair dismissal. And that is a possibility. That is something that they would be able to do. So it's just something to be alive. I suppose it's an extra avenue or potential extra cause of claim the employer may have. Now, notoriously, constructive dismissals are not as common because obviously the employee has to show that the breach was the cause for the employee's resignation. So, you know, there's quite a few hurdles. Has the employee committed a breach? Was it a repudiatory breach? Did the employee resign in response to that? So I suppose technically it's a more difficult claim to, I suppose, succeed on in a general fashion. But it's something to be alive to. And ultimately, if we're doing all the things that I mentioned before about taking on board, not acting in haste, taking on board comments, looking at the situation and the full set of circumstances before we act, we're unlikely to have to concern ourselves with this. But again, that kind of knee-jerk response where you may be placing them to a detriment could well mean that actually the employee could resign and look to claim constructive unfair dismissal. So be aware and alive to that. Okay, I've dealt with that. So the health and safety and protected disclosure is another area which is, I suppose, interconnected with health and safety that you need to be mindful of. Now, protected disclosures, sometimes you perhaps might be familiar with this subject matter as whistleblowing, if protected disclosure is not ringing a bell. So if I just do maybe a whistle-stop tour of the basics of, you know, whistleblowing, or what is a protected disclosure, and then we can look and apply that to I suppose the coronavirus and some of the issues that it may well present, or the risks it may present to employers. So if an employee raises a protected qualifying disclosure, or they raise a protected disclosure and the employer places them to a detriment or dismisses them, then they will have a cause of action. And it's the same situation regarding no cap of compensation and no need for the 2 years continuous service to raise this claim. But what does a protected disclosure look like? What is that? Now, for something to amount to a protected disclosure and for an employee to benefit from its protection, the employee must disclose information. And that information must relate to one of the 6 relevant matters. And health and safety is one of those 6 relevant matters. And the actual relevant section we've put on the slide there. So under section 43B(1)(d) of the Employment Rights Act, informing an employer that the health and safety of an individual, so it could be themselves, for example, has been, is being, or is likely to be endangered, can be a qualifying disclosure. So if it's a health and safety disclosure, so I suppose applying that to the current pandemic situation, if an employee says the employer is not filling up its hand sanitizers, it's deliberately flouting the COVID secure guidelines, that would, in my view, satisfy a disclosure in the sense of it being a relevant matter under section 43B. But a protected disclosure, it's a disclosure of information. The information has to be one of the relevant matters, and health and safety is one. They have to have reasonable belief. So I suppose using that sanitizer example, if they've been told by a colleague that that's happened, but actually, you know, that person's always maybe making up stories or whatever, they don't really have reasonable belief that the hand sanitizers haven't been filled, they're not going to satisfy that test. So it's got to be disclosure of information, relevant matter, which could be health and safety, and they have to have reasonable belief, and it has to be in the public interest. Well, I think that's going to be pretty easy for an employee to satisfy, because if, for example, in the scenario I just gave, an employee is deliberately flouting the COVID secure guidelines, then obviously there's a risk to the whole workforce potentially. So if an employee has made that disclosure and done all of those things, and the employee dismisses them or they place them to a detriment, then they are going to have a cause of action. So when we look at this in the context of what might occur, I know it's a bit of a basic example that I've given regarding the hand sanitizers, but that's you know, a basic example that displays the situation. So if an employee has raised this and the employer's reasonable belief that that's what's going on, and then the employer kind of reprimands them for that, then they're going to fall foul of this protected disclosure and, in effect, whistleblowing. So just be really alive to this. Suppose practically maybe want to revisit whistleblowing policies. I'm not suggesting you need to start putting extra detail in there regarding COVID, but just making sure you've got the appropriate policies in place, which the HR3 members who have our handbook with a whistleblowing policy will have, just making sure that you have got that in place. The way it's likely to present itself, this protected disclosure, is probably most likely in a grievance. But this is why it's helpful to have a whistleblowing policy, because you can set out in there how you would like employees to raise that disclosure. If they don't follow that, that doesn't necessarily mean automatically it won't be a protected disclosure, but you can influence and encourage people to raise it in that fashion, so that you don't miss something, by accident. Okay. Okay, discrimination and health and safety. I'm not going to spend a lot of time on this, because as I said at the beginning, Emma is going to do a discrete session fully on this. So she's going to spend an hour looking at the subject matter of discrimination in the context of obviously the pandemic and generally. Many of you will probably be well rehearsed already in the sense of dealing with disability related matters, maybe long-term capability, ill health related matters, but none of you will be used to dealing with that in the context of a pandemic. So I suppose what I wanted to highlight here from the beginning is 2 points really. One, somebody who's had COVID and suffered extensively from that, maybe being in intensive care, we can't outrule that those individuals aren't suffering from a disability. So what a lot of you will be familiar with the definition of disability. It doesn't just mean a blue badge holder, although those that satisfy the test may well hold a blue badge, but under law, under the Equality Act, under section 6, it sets out what is a disability, which is a mental or physical impairment, which is long term, so lasts more than 12 months, which has a substantial and adverse effect on the employee's ability to carry out day-to-day activities. They love using snapper definitions, don't they, in legislation? But so it's quite a lengthy subjective test, and that's why we often get employees to go to occupational health to get a steer. We're not medical professionals. I'm not. Many employers aren't. Ultimately, it's for the employment tribunal to decide whether somebody has a disability, but often we will get somebody who we think may have a disability to occupational health to give a view on whether they believe they satisfy that section 6 test. So that then places the employer in an informed position of what obligations are on me now that you're aware that this is the case. So 2 points to note. I don't think coronavirus obviously is I know coronavirus isn't a deemed disability, but I think it potentially may satisfy the section 6 test, so be mindful of that. In addition, many individuals who have previously been shielding or considered vulnerable or extremely vulnerable are likely to satisfy the test for disability. So if they are, that throws up a whole host of additional considerations for you to have. So if people, using the example we looked at right at the beginning, are refusing to come into work, then obviously you would do all of those things that we discussed before you entertain or even think about dismissal, but also be aware that this individual may well have a disability. So there will be other points for you to consider, and I'm going to briefly touch upon those now. So there may be direct disability discrimination. So under section 13 of the Equality Act, a direct discrimination is where a person discriminates because of a protected characteristic. So whether that be race, gender, disability, sexual orientation, religious belief, etc., etc. Because of a protected characteristic, they are treated less favourably than others are treated. And if an employer conducts the behaviour in that fashion, then they're going to fall foul of direct discrimination. Now, for the relevant, I suppose, for the purposes of COVID and the pandemic, for a direct discrimination claim, we would be looking at the employer having to cite a comparator. Now, the comparator would be somebody else who is off or refusing to come into work who doesn't have a disability, and how have you been treating those individuals? So I suppose a word of warning in relation to if you're, applying, for example, some people are off not coming into work, you're paying them full pay, and others you are. If you're being inconsistent in how you approach that, inadvertently you might find yourself falling foul of this. So, be mindful of what direct discrimination is, and make sure that obviously you aren't acting in a way contrary to that. So a couple of very basic examples. So a requirement imposed by an employee to continue travelling to and attending work, not pay them or dismiss them due to their absence in this scenario, that could amount to discrimination. It could be automatically unfair as well. So just be alive to that. Okay. Oh, indirect discrimination. So under section 19 of the Equality Act. So you may, as a business, engage or implement policies or have a practice or criteria that you apply equally to everybody. So you don't think you're being discriminatory because you're applying this policy equally to everybody. Let's use a practical example in the COVID scenario, a little bit far-fetched perhaps, but let's say you introduced a hugging policy, okay? So you're implementing that across the board equally. However, certain groups of individuals who have a protected characteristic are likely to be put to a significant disadvantage because of that. For example, those perhaps who have got a disability who are extremely vulnerable to COVID may be older individuals, so it might be age, or potentially religious. We know that BAME, Black, Asian, ethnic minority individuals are at greater risk of COVID and its potential consequences. So be mindful that if you are implementing policies across the board, that by virtue of doing that, you're not being, make sure that you're not being discriminating indirectly against individuals. So again, applying this to COVID, if you're saying everyone has to now be back at work, shielding's no longer a thing, we want everyone back at work, then potentially it could be indirect discrimination. So make sure you're considering individuals on a case-by-case basis and looking at those circumstances before you're making that blanket approach. Make sure that where appropriate you're making reasonable adjustments, and we'll look at that shortly. Okay. Discrimination arising from, I'm not going to deal with that at all. I've put the definition on the slide, but Emma will pick that up in much more detail in her session next week. What I do want to quickly touch upon though is reasonable adjustment. So under the Equality Act, under section 20, you are, as an employer, under an obligation to make reasonable adjustments in scenarios where an employee has a disability. So satisfies that section 6 test. As an employer, you're under an obligation to make reasonable adjustments. So from a pandemic perspective, what might that look like? It may be, you know, those individuals that have been shielding, if they are at risk and they are requesting to work at home and you're able to accommodate that as an organisation, it is likely that that will be considered a reasonable adjustment. Now, practically, because you're likely to be in a situation presently where many employees are starting to come back into the workplace who have been shielding and may well have a disability too, it practically, you want to be talking to them about them having return to work meetings with them, and it may well be appropriate to get an occupational health referral and asking for comments specifically on whether any reasonable adjustments would be considered appropriate, and then obviously looking at whether the business can accommodate that. That's important to be doing. I think it's quite timely that this is talked about because, as I say, you're going to have perhaps a group of individuals who are starting to integrate back into the workplace who are the ones most likely to satisfy that disability test. Okay. What I wanted to briefly reference is anxiety. I think there will be many individuals who are incredibly anxious about coming back to work. And there is, of course, I suppose, a spectrum of anxiety. There may just be people who are worried, but there may be people who have significant anxiety conditions that may well amount to a disability because they're able to satisfy that section 6 test that I mentioned before. It's an important one to know, and I think it's something that I've seen come up quite a bit, but it's, I suppose, being in an informed position to be able to identify, is this somebody who's, without seeming unsympathetic, swinging the lead and just trying to be difficult, not wanting to come back into work, or is it somebody who's actually really quite seriously suffering from anxiety, may well be a disability, really concerned about coming into work? And I think for the latter, you would be wanting to get them to occupational health and make sure you fully understand the condition and whether any reasonable adjustments can be provided by the employer. ACAS have done quite a helpful guidance note on this actually that you may find useful, and for those that are interested, I'm happy to share the link with you. That might be quite helpful to read. But practically speaking, if individuals are presenting this as a concern, referencing anxiety, the first step will obviously be to discuss it with them, but it may well be appropriate again to get them to occupational health to really understand the full extent of the condition and whether actually it amounts to a disability, and therefore in turn throws up these obligations for us to undertake. Okay. I think I've mentioned the shielding piece in reference to the 1st of August date, and that the government is no longer recommending that the clinically extremely vulnerable people shield, and have advised that they start returning to the workplace. So this is quite timely that we're having this session. I'm hopefully highlighted the practical tips on dealing with this, making sure that you're having return to work, making sure you are engaging in dialogue regarding the measures you've taken following your risk assessments. Make sure that you're addressing their concerns. Talk to them. What are they concerned about? If they are, have they got questions about the safety? You may well have really simple responses to that, and you've already done everything you can, and the employee's quite satisfied. But in situations that become a bit more complicated, where the employee is refusing to come back into work, then we'll be looking at all of those things that we mentioned regarding an SOSR dismissal, potentially looking at talking to them about the matter, discussing measures, but also potentially getting them to occupational health to understand the extent of their condition. And I imagine that many of you will probably be grappling with that now. I don't know whether it's a bit difficult just to have a general discussion now over a webinar, but I don't know whether many of you have encountered concerns and issues in relation to the shielding no longer being around, and whether employees are refusing to come back to work since Saturday. But we can maybe leave that for when we get to the questions. Okay, so just a quick, I suppose, summary really of the main points that hopefully I've brought to life, and also hopefully have resonated and you're comfortable and you understand those. So first of all, it is the employee's belief. I think we made that point clear. That is relevant, not the employee's opinion. Danger, widely interpreted. Actions of other employees count. Potentially the commute could be, even though it's not in the workplace. Potential danger needs to be imminent. It doesn't have to be a fellow worker. We've talked about danger not having to be a fellow worker. Could be others, so family members who are vulnerable and at home. Damages under section 4400, no qualifying service for those. Possible constructive dismissal claims if employer fails to deal adequately with some of the points that are discussed regarding section 4400 as well. Rights are not individual, not collective, and I didn't go into that much detail about that, but the point on that is there was a particular case where a group of individuals had taken part in unlawful strike action and then looked to claim section 100 and weren't successful. So it's just a minor point, which I don't think many of you will come across anyway, to say that the right is the individual. You can't benefit from the section 100 and section 44 protection as on a collective basis. Protection could potentially extend to workers, and employers must be, I cannot stress this point enough, must be clear about action they are taking and why. So remember that point, you're not penalising the employee for their appropriate steps. It's not a retaliation, it's not a knee-jerk response. If you are going to be able to dismiss fairly in circumstances, you need to not act in haste and consider all the circumstances in the round. Okay, well, that brings the session to an end in relation to what I wanted to share with you. What I'm happy now to do is open the floor. If you want to type the question because you don't want to speak out loud, that's fine. If you just type question and then your actual question, and Charlotte can read it out. If you're happy just to ask your question verbally, then just put question in the box and Charlotte will unmute you now. So Charlotte, can I turn to you for questions?
Yeah, there's none in the box at the moment. I don't know if anybody does have any questions at all.
Does that mean I've dealt with everything really thoroughly, that there's no questions
I think
left?
it does.
Oh, right, okay.
Yeah.
I'll run with that. I'm happy with that. I mean, if people don't feel comfortable in asking those questions, I mean, often my view is that many attendees benefit not just from one of us lawyers talking about things, but actually the questions that others ask, because you'll find that many businesses are in the same predicament. But if you're not comfortable and you want to email me separately or ring me separately, then I'm happy to take a call. But don't be shy if you do have a question. I'll give couple more minutes, and then if nobody's comfortable in asking a question, then we can just, we'll bring it to an end. We'll bring the session to an end. Have we got any takers, Charlotte?
No, Bob's just explained that he was joining for information. He's not got any scenarios at the moment where this applies, which we're glad for, but he said that you've presented clearly, and thank you very much.
Oh, lovely. I'm glad that's helpful then. Okay, well, if there aren't any further questions, then I will say goodbye to everybody. I hope this has been helpful. I hope it's not kind of instilled the fear into you. I just want to hopefully give you the tools to be able to ask the right questions. And ultimately as well, if you're asking the lawyers the question and they're not able to give a 2-minute answer, you'll know why now. It will take some time to go through those different steps. But hopefully it's been helpful and interesting, and thanks everyone for attending.